Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. In this video, I'm going to briefly discuss ways in which one can leave the United States and sort of briefly touch on some of the ramifications, although please note this video is not exhaustive on these topics, and anyone viewing this should go ahead and, if you want detailed information, contact a legal professional. But basically, what we're going to be talking about are things like voluntary departure, as opposed to deportation, and then finally expedited removal, which is a slightly newer variation on an old theme. So in the past, we basically had two things we were really talking about with respect to leaving the USA and subsequent possible inadmissibility. What are we talking about here? I'm talking about, let's say somebody overstays in the United States or commits a crime in the United States, falls out of immigration status, has some sort of issue in the United States. They're not a United States citizen. They may not even be a United States lawful permanent resident, and for that reason, they may be either subjected to deportation, or in the past, they choose to go ahead and what's called voluntarily depart, voluntary departure. In the case of voluntary departure, the underlying issue of whether they left of their own accord voluntarily, as the name implies, is sort of dealt with straight away. It can be seen that that individual has gone ahead and left the United States. Now, it should be noted that voluntary departure as opposed to deportation should not be seen, voluntary departure in and of itself should not be seen as something positive per se. An individual may choose to leave the United States voluntarily, but an issue that created an issue for why they couldn't stay or might not have been able to stay could create a legal ground of inadmissibility with respect to once they're back abroad processing a later visa application. So voluntary departure in and of itself is not necessarily a good thing or a bad thing. It's just a status of departing the United States. This is opposed to deportation, which is, for lack of a better term, forced removal from the USA. It's basically one's placed in proceedings. If it's adjudicated that the individual in question should leave the United States, and an immigration judge concurs in that, finds that to be the case, then that individual, presuming there's no appeal, or if on appeal it's decided that that individual doesn't have a justifiable reason for remaining in the United States for any number of reasons, that individual will be deported. Now, that deportation is going to be noted on their record if and when they try to go back to the United States, re-enter the United States. That individual, if they're found by, say, U.S. Customs and Border Protection, that information is going to be pretty much immediately apparent to a U.S. CBP officer when they're trying to come back into the USA. So, like at, say, a port of entry. So those are kind of the old school ways to look at this. You had voluntary departure, you had deportation. Most people sort of understand how that worked. Expedited removal was created at the end of the last century. It's slightly old. It's a slightly newer concoction created under the IRA Act, an immigration amendment essentially created by Congress. Expedited removal is essentially a creature. It's not exactly in between voluntary departure and deportation. It's essentially a proceeding that an immigration officer, specifically a U.S. Customs and Border Protection officer usually, at a port of entry in the United States, can go ahead and initiate expedited removal proceedings if they feel that there's possibly, some sort of suspicious activity, or the individual in question doesn't have the kind of intentions that they're stating when they're entering the United States. And if found removed, the individual may be barred for a significant period of time from re-entering the United States. So it's a bit like deportation, but it's oftentimes deportation light. In many of the cases I see involving expedited removal, the period of time that the individual is going to be banned is approximately 5 years. in and of itself for the expedited removal issue. Again, there are waivers available for these type of things, and I'm not talking about any other underlying grounds of inadmissibility. Other underlying grounds of inadmissibility, say crimes involving moral turpitude or another prior overstay, other criminal grounds of inadmissibility, things of this nature. These sorts of things are going to be compounded on top of a possible expedited removal or a deportation. So things to think about: drug inadmissibility connected with, say, narcotics violations. Oftentimes, those kinds of inadmissibility never go away. That individual may be inadmissible to the United States for the rest of their natural lives. The same thing goes for things like claiming U.S. citizenship when none in fact exists. These sorts of things are very delicate matters, and also they're delicate matters in certain contexts, but at the same time, they can have tremendous ramifications, because an individual may not be able to get in the United States ever again, based on one of these findings of inadmissibility, notwithstanding the way they departed. An individual who has drug convictions in the United States, narcotic convictions in the United States, or abroad for that matter, who voluntarily departs the USA, those underlying inadmissibility problems don't go away just because that individual decided to leave on their own accord. And they won't necessarily go away under any circumstances, depending on the facts of the case. Again, as stated at the opening of this video, this is not an exhaustive video. It's simply to provide some overview and some context into how some of the dynamics of this work. I strongly recommend contacting a legal professional who deals with immigration matters, preferably a member of the American Immigration Lawyers Association, as these can be rather discrete, extremely complex matters depending on the specific circumstances of a case. And so for that reason, it's very advisable for anyone who has any of these issues or thinks they have any of these issues to contact an American immigration attorney at the first possible moment of availability, and go ahead and get some answers with respect to one's specific circumstances.